Good afternoon, everybody. I hope everybody is keeping safe in this pandemic situation. So today we will be discussing Module 11 of our course on criminal law. And Module 11 focuses on the topic of witness under the Indian Evidence Act. Now, who is a witness? In layman's language, if we see, witness is someone who is acquainted with the facts and circumstances of the case and whose testimony or whose statement can determine the outcome of a case. Section 118 of the Indian Evidence Act talks about who may testify. So when we go through section 18, the bare provision is as all persons shall be competent to testify unless the court considers that they are prevented from understanding questions put to them or from giving this null answer to those questions by reason of tender year, extreme old age, disease, any of body or mind, or any other cause of the same reason. Now, as per section 118, any person is competent to testify who is acquainted with the facts of the case, provided that he does not suffer from any of the, problem, maybe, that he is immature to understand the question that is put to him. He's extremely old, reason being, that his memory is not very as fresh as it was during his younger age, or he suffers from any kind of disease. So the main provision, the main motive behind the inculcation of section 118 is that it is up to the judge to decide who is competent to testify during the course of trial. Now, this, competency does not depend upon personal reasons like his religious belief or his educational qualification. It depends upon the judge, and the judge determines it that whether the question that is put forward to him, whether he has that, conscious level of mind that he can answer the question that is put forward to him, which will determine the outcome of the case. And, by competence over here, they do not mean the possession of any qualified degree, but to know that whatever question is being put to him, his answer is correct as to the facts and circumstances of the case and will be important in determining the outcome of the case. Now the question arises that, here we have who can be competent to testify, or what case laws do we have? So there was one case of the Privy Council. The citation is Muhammad Shugal versus the King, AIR 1946, Privy Council 3. So the facts of the case, in this case, what was held was that there was a girl who was 10 years old, and she saw, when a particular crime was being committed, she was one of the eyewitnesses to this case. Now she was called before the Privy Council to, give these, record her statement or to give the evidence as a witness, as an eyewitness to the case. There were pleas being raised by the defense counsel that she is too tender, but the Privy Council has held that the age on paper does not determine it, whether a person is competent to testify it or not. Herein, the girl was considered to be much brighter than of her age. As a result, her evidence, or she was considered competent to testify as per the Indian Evidence Act, section 118. Now, another thing that can, when we are talking about the old age, all these factors, it depends upon how the judge perceives it and how, the statement that is given. Because when any person of old age, when we talk about old age, it is not written over here as to what shall be the age of the person who is not allowed to give the evidence. But there have been instances when you will be dealing with the criminal appeals, we see even the statement of a person who is 70 years of age, or normally in our country, anyone above 60 or 60 is considered to be a senior citizen. So he will fall within the domain of the old age. But when we are talking about the competency of the witness to testify, that is why, it has been stated, the notes that I have also provided to you, if you go through the second para of it, it states that the court has to ascertain in best way possible with the extent of his intellectual capacity and understanding, whether he will be able to give a rational account of what he has seen or heard, meaning hereby that he cannot be manipulated. That is what the court has to see. Now this takes us to the next topic, that is the dumb witness. Now, as the word suggests, dumb witness is one who cannot speak. Now the question arises, how can a dumb witness be considered to be a competent, can he be considered as a competent witness during the course of trial? So if you go through section 119, it states that a dumb witness can be a party. His evidence may be given, so he can reduce it in writing and give it to the court. And that the statement that he has given should be supported by his own signature. It cannot be, that any of his, we can say, signatories or anybody whom he has authorized cannot make a signature on his behalf. It has to be his own signature under section 190. Now, section 120 of this act talks about whether when there is any civil or criminal trial going on in the court of law, the wife or husband of the particular person who is, charged with anything or who is in question, his statement can be considered, he can also be considered as a competent witness. Section 120 states, in civil proceedings, the husband or wife of any party to the suit is a competent witness. Similarly, in a criminal proceeding against any person, the husband or wife of the person shall be a competent witness. Now, why the main theory behind having them as a competent witness is that suppose if it is any criminal case and any husband has been charged with any offense, and the question arises as regards the character of a person, or anything, then obviously the wife is in a better position to judge it. Normally, people can say that due to the relationship that they have, they may give statement in their favor, but it is up to the judge to consider it or not while pronouncing the judgment. But as per section 120, they can be considered as a competent witness. If the defense counsel wants to produce them, then he can, with the permission of the court, produce them as a witness as per section 120. Now section 121 talks about judges and magistrates as witnesses. Now judges and magistrates, if you go through the initial portion, the beginning portion of section 121, it states a judge or magistrate is competent witness, but he cannot be compelled to give evidence about the matter in which, or about the proceeding in which he has been judicially engaged. Now, there is any trial which is pending before a judge or a magistrate, then an appeal is made before the High Court. Now, a judge or magistrate, if he has passed an order of conviction, acquittal, or anything, he cannot be called, and asked to give, as a witness. But there are exceptions. In what cases? Exceptions to the judicial privilege as given under section 124. In the following cases, a judge or magistrate can appear as a witness with the order of the Supreme Court to which he is subordinated. Now, if the Supreme Court orders that he has to appear, there is certain observation that has been made by him, which the court thinks that is important to be questioned during the course of the proceeding, then they can be called. We can take a very good example of it. We have this when we have the course of the principal secretary law. So wherein, if any proceeding or anything that takes place when state, new state government comes and they want to withdraw the cases, in that case, the Supreme Court can call the principal secretary, and therein they are not called in their personal capacity, they are called in their official capacity to answer it. This is what they mean. So if in case of any judgment which is of great importance, then the Supreme Court can ask him to appear and give this statement as a witness for facts which he has observed as ordinary man while he was acting in his judicial capacity. So when the judge passes an observation, there are some observations which he makes on his own account. We use the one as a man of ordinary prudence. So as regards those observations, he can also be called as a witness, and he can waive his privilege involuntarily offered to explain his conduct as a judicial officer. And if he himself waives his privilege, or even then also he can be asked to appear as a witness. Now section 122, it talks about communication during marriage. It is somewhat similar to section 120 of the Act. it talks about any communication that is made by the husband or a wife during the course of marriage. Marriage is considered as a sacrament in our country. So that is made, so they cannot be compelled to disclose that in the court of law. So they, a husband or a wife can be compelled to be a witness, but not to disclose anything which is personal between them. Now, this was about your witnesses. Now this takes us to an important provision under the Act, which is under Section 130. Before that, Section 129, it talks about communication with the legal advisors. Now, suppose to sum it up in a simple language, what it states is that as a litigant, you go and meet the advocate. There are some confidential information that you give him. So in that case, your communication is confined to your legal advisor only. The court cannot compel you to come and give any statement or any evidence as a witness and ask you, compel you to make those statements which you have given confidentially to your legal advisor. Section 130 talks about production of title deeds of witness, not a party. Now, Section 100 found that a witness cannot be able to produce the following document in a case which is party. What are those documents? Now, when witness is being produced, there are some documents as regards which he cannot be compelled to produce them. Titles Act talks about production of title deeds of witnesses, not a party. Now, Section 130 of the Evidence Act lays down that a witness cannot be compelled to produce the following documents in a case to which he is not a party. Now, there are provisions given under the Evidence Act which state that anyone who is not a party to a case, but he is in possession of any document which plays a relevant role in deciding the outcome of the case, he has to produce those documents, but not these documents as under Section 130. His title deeds to any property, any document by means of which he has become the mortgagee of any property, and any document which might tend to criminate him. Now this takes us to Section 132, which talks about that witnesses not excused for answering on ground that answer will criminate him. Any witness during the course of trial, if he is compelled to answer anything which is an important question and he thinks that it will criminate him, then he cannot take the defense because they are provided the protection. Suppose any particular question is being put to him and in that regards he thinks that he might be criminated. No, he cannot be because a protection is being given under Section 132. But if he voluntarily wants to answer any other question and if that answer to that question criminates him, then of course he can be charged with an offense, but not to the question to which he is being compelled to answer. Another witness, which is the accomplice, which is given under Section 133. An accomplice is a person who, along with another or others, has taken some part, large or small, in the commission of the crime. It is a general term and is used to designate the person whom the police, for some reason, do not arrest, but call as witness for the prosecution. If he is the person induced by the police to take part for the purpose of collecting evidence against other, he is called as a trap witness. Now, somebody who has taken a part, not like as in criminal conspiracy, but is acquainted with it, then that person is known as an accomplice. Similarly, the question is how many number of witnesses can be called. There is no particular number of witness as given. It depends upon the circumstances of the case. Now this takes us to the remaining topics. The last one, which is the order of production and examination of witnesses. Now 135 deals with it, and your Section 136 talks about that judge will decide the admissibility of the evidence. The main aim of this section is to bring forth only relevant evidence on record, because a lot of evidences can be produced and it will only increase the time of the trial. So therefore, judge decide as to what evidences can be permitted to be given and what can be made admissible in the court of law. Now 137 talks about how there are stages in the examination of witness. The very first stage is examination in chief, which is the very first stage. Examination in chief is done by the party who calls him. Suppose the prosecution calls his witness, so the question put forward by the prosecution to the witness are examination in chief. Cross-examination, a prosecution calls his witness, the question put by the defense counsel to the prosecution witness will be the cross-examination. And re-examination is if after the cross-examination, the party who has called the witness seeks to question him again. Now, prosecution has called a witness, the prosecution put forward the question to him, that will be called examination in chief. Thereafter, the defense questions the witness of the prosecution, that will be called the cross-examination. And thereafter, the prosecution wants to again question his own witness, that will be called re-examination. Now, there's another term that we use, that is the leading questions, which has been defined under section 141. It states a question is a leading question when it indicates to the witness the answer which he is expected to make. Now, section 142 talks about when leading questions must not be asked. As per this section, leading questions should not be asked in examination in chief or in re-examination if they are objected by the adverse party. And section 143 talks about when the leading questions may be asked. The leading questions can be asked in cross-examination. So if you go to 142, it states it cannot be asked in examination in chief or re-examination, because leading questions are those questions which witness expects to answer. He knows that a prosecution witness is being produced, and the question that is put forward to him will strengthen the case of the prosecution side. That will be a leading question. The answer that his counsel expects him to give to the question is the leading question. Therefore, leading question shall be asked it is stated only in the cross-examination. Now, 146 talks about court questions lawful in cross-examination. When a witness is cross-examined, he may, in addition to the questions herein before referred, be asked any question. Now, what questions can be asked in cross-examination as per section 146? Questions to test his veracity, to discover who he is and what is his social position, to shake his credit by injuring his character, although the answer to such questions might tend directly or indirectly to criminate him or might expose him to a penalty or forfeiture. Now, section 148 states that it is the court which shall decide when the question shall be asked and when witnesses shall be compelled to answer. If any question relates to a matter which is not relevant to the suit or proceeding, except in so far as it affects the credit of the witness by injuring his character, the court shall decide whether or not the witness shall be compelled to answer it or not. And such questions are proper if they are of such a nature that the truth of the imputation conveyed by them would seriously affect the opinion of the court as to the credibility of the witness on the matter to which he testifies. And such questions are improper if the imputation which they convey relate to matters so remote in time that it affects the time of the court. Similarly, section 149 states that questions should be asked with reasonable grounds. They should not be based upon unreasonable grounds. Now, section 151 talks about indecent and scandalous question. It states, the court may forbid any question or inquiries which it regards as indecent or scandalous, although such questions may have some bearing on the question before the court unless they relate to the fact in issue. So, indecent or scandalous questions may be forbidden by the court unless they relate to the fact in issue. Now, this takes us to the section 159. 159 talks about refreshing memory. Now, suppose any witness during the course of trial, he has given any statement or any document, and he has forgotten anything in relation to it, then his memory can be refreshed by producing the secondary, we can say, the second-hand copy or the photocopied of it, not by original, but by producing it. If he forgets anything, that the secondary document of it can be produced and his memory can be refreshed. Now, this was all about the concept of witness. and the questions that are put forward to them. If there are any questions which still subsist, please let us know. We will answer them.